During the last 12 months, the SEC reports that this market is $2.7 trillion. It's larger than the market for new money raised on Wall Street. This is huge business. And then somewhere, everything got out of hand. Regulation D was a big, big deal. I sent out 1,676 K1s one year. 96% of the $2.7 trillion is raised in 506B. I was an educator. I've always been an educator. I have very few other interests, so I might as well just work. My hashtag is not retiring. Because you put two people together to do some business venture, it's a syndication. So the rule is every security has to be registered with the SEC unless...
Welcome back to another episode of the Syndication Show. My name is Kalani Michelle, and I am here with my co-host, Mr. Christian Sadler.
Hey, everybody.
And we have a special edition of the Syndication Show today with Mr. Gene Trowbridge. Gene, thank you so much for coming on today.
Well, thanks for having me, Kalani and Christian. I appreciate it.
You're welcome. And I'll let Gene dive into a little bit more about himself. We do have his book. He is an author and of this book, which we have read here at PREIshare. It's A Whole New Business, the How-To Bible of Syndicated Investment Real Estate. And this book is full of great information, Gene. I was highlighting, I was taking notes and all that. So thank you for writing this for those of us in this industry to learn how to better serve the industry and to really just raise the bar within the industry and help it operate in a more efficient manner.
Well, that's pretty good. I always wondered who the one person was that bought that book. Thank you very much.
You're welcome.
If I can sell another one, I can retire. Yes. No.
Well, Gene, I actually bought two. I bought the hard copy and the audio.
Then I'm retired now. Bye.
No. Well, and I'll tell you, Gene, this was actually required reading for us when we started working with Michael Anderson, who you've known for many years. This was one of the first books that he said, you guys need to read this one and really get familiar with this business.
Good, and we have the fourth edition now, which was written at the most recent change of the securities laws, and I really had to totally rewrite Chapter 5. And maybe we'll talk about it a little later, but there might be some changes coming up toward the end of this year and the beginning of 2024 that might just require me to do the fifth edition.
Did you know you'd have so many editions when you first wrote it?
No. Actually, I wrote it first. What I was doing is funny. I was doing live classes talking about syndication, and I had a 2-day PowerPoint presentation slide deck that I taught when I taught my 2-day classes. And I sat down one day and I said, what if I just dump those into Word and then just type what I say about each slide and make a book out of it? So that's how it came about. It took, it was, I'm sure, 18 months. And I finally just stopped and said, well, that's enough. Let's just print this sucker and move on. But I never thought I would do all those editions. But you could if you wanted to. I know some authors do it. There's probably 2 or 3 typos in the book, and I could change the typos and say, hey, this is the 17th edition. But I don't do that. So
Gene, I'm sure most of our audience knows who you are, as it seems everyone in this industry does. For those that are watching right now that may not know who you are, can you get a little bit of background with your experience in syndications? Now you're an attorney, you're an educator. I mean, you're doing so many great things, but if you can just, tell our audience a little bit more about who you are, that'd be great.
Thanks. I'd like to. I came out of college and started selling real estate. I was a commercial real estate broker, and somewhere along the line, like every syndicator I know, I found a piece of property I wanted to buy, and I didn't have all the money I needed to buy it myself. So I reached out to my friends and said, let's pool some money and let's buy something. And that was a long, long time ago. And I kind of liked that. I liked managing the investment for my investors And my brokerage career really morphed into a syndication career. So for about 20 years, I was a syndicator, and the biggest part of that 20 years, I was building self-storage facilities down in Southern California, building them to sell them. We probably would hold them until we were 25% absorbed, and then we would sell it to long-term operators, which we didn't want to be long-term operators. So that's where the 16 syndications that I talk about in my book, it was 32 storage facilities that we built. And then somewhere, everything got out of hand. I sent out 1,676 K1s one year. And in those days, there was no back office companies involved to help you. We did it all by ourselves, licking stamps and licking envelopes. And I went home and sat with my wife at the kitchen table where all the good decisions are made in my life. And I said, I've had enough of this. I had 850 investors, and I was going to have to grow. It was just going to, and I said, I don't want to do that. This has been a good run. I've made a lot of money. I want to get out of this. And so I applied for law school and went to law school. When I was 45, I passed the California bar. And ever since then, I put my syndication hat away and have been an attorney just exclusively in the syndication business, not exclusively in real estate, but 90% is real estate. And it's been a great career. You mentioned, Maloney, that I was an educator. I've always been an educator, and whether it's education-based marketing, trying to find clients, or just teaching people what to do so they can be more successful in their career, that's what I've done, and that has spilled over to being an attorney. And so I get fired up about that. I have passion about that, and my hashtag is not retiring. That's my hashtag. So and there's a long story behind that, but anyhow, it's not retiring. So that's me.
It seems like you're a lot like Mike here, who you try to retire, but retiring just means finding a new way to make money and make other people money in the process.
Yeah, I have very few other interests, so I might as well just work.
Yes, when Mike was our advisor to start, and he has a wealth of knowledge, and I don't think he knew what he was getting into at first when we were like, but Mike, how would we do it this way, and how would we do it that way? And we roped him in slowly but surely. So, and here he is now, our president and CEO, and we're so grateful to have him on. And I know you've had the pleasure of getting to know Mike also, Gene.
About 42 years worth, yes, of course.
42 years. That was before I was born.
And I've spent 42 years trying to grow a beard like him, and you see how far I get.
Well, Gene, let's dive right into the meat of it. Why don't you help us understand the different structures there are out there if one wants to syndicate a piece of real estate or anything else for that matter, but especially real estate, because that's our audience.
Well, let's talk vocabulary just for a second. I get a lot of what I call homework. Homework calls. People call and say, I want to put 10 people together, buy a piece of real estate, but I don't want it to be a syndication. Well, that's a bad question, because you put 2 people together to do some business venture, it's a syndication. There are all sorts of syndication examples in our career. You watch television, you go to a movie, and there are a bunch of people who have worked together to create that television show. That's a syndication. You jump on an airplane with 140 of your closest friends. That's a syndication, because you're trying to get somewhere and you don't own the equipment. You're not a pilot. It's all that. But when people are calling me and say, I want to get some investors, I want to put them together, I want to buy something, and I want to manage it, the question is, Gene, I don't want it to be a security. That's the real question. And so once you get past the fact that when you're pooling investors, it is a syndication, then the first thing you have to answer is it a security? And once you answer that question, we can delve into, Christian, into your question which way to go. It's kind of a flowchart world. The first question is it a security? And as simple as I can make it is if your investors are passive and you're taking money from passive investors and you're managing it, and the results are going to be driven by you, it's a security. Technically, it's when there's an investment of money in a common enterprise with an expectation of profit through the results of someone else. That's the Howey test. Okay. So that's the way we go. So now it's a security. So in my flow chart, I'm saying, okay, first question I have to have, is it a security? And you can say, no, it's not a security. And why is it not a security? The three of us put our money together and do something, and we decide that we're all going to make the decisions. No one's in charge. All decisions, all major decisions have to be unanimous. Refinancing, selling, whatever, have to be unanimous. Well, there's no passive investors in that deal. So that's what I would call a member managed LLC. We'll form an LLC. We've got 3 members and we make all the decisions unanimously. So that's not a security. So you can turn off the video and not watch the rest of this if that's what you're going to do. But if you're over here on this side of the flow chart and there's a manager managing the money for all the passives invest in the LLC, but there's a manager running it all, making it happen. Now we have a security. Is that okay so far?
Makes a lot of sense. Yeah, with your experience, is there a magic number from where you go from I would call it a joint venture, or where everybody is making the decisions versus you decide you're going to switch it to a security?
There's no magic number. I just think you probably can imagine some number of people where it gets pretty difficult to make unanimous decisions. And it is truly unanimous. You guys may put up 90% of the money, let's say 45 and 45, and I put up 10. We all have an equal vote. If you can outvote me, we'll fall into the securities definition that you're in charge of my money because you can outvote me. So at 5, 10, 15, I don't know how many it is, but generally it's not many more than 2 or 3. It just doesn't work. And I imagine if it's 3 or 4 or 5, you call it a member managed and you want to stay out of the securities laws, but if push comes to shove and it was investigated, you probably do have a security. That's what I think. Now it's a security. And the rule is that every security has to be registered with the SEC, this great big organization in Washington, D.C. Before you can do anything, you have to take your security to the SEC, and they read every word of what you write, and they test all of your assumptions. So you go to this big organization in Washington, D.C. to get everything approved, and it's months, and it's hundreds of thousands of dollars. So you don't want to do that. So the rule is every security has to be registered with the SEC unless it's exempt. That's pretty good. Now, how do we get it to be exempt? Well, follow the rules. And the most popular way of getting a security exempt is to use Regulation D. 1981, when I was syndicating, Regulation D came along, major statute and legislation. It did a number of things. It defined what an accredited investor was. It said that you have to have a PPM, that a private placement memorandum, you have to have those documents. You have to file a Form D to tell the SEC what you're doing. They don't judge it. They don't do anything. It's just an information gathering form, but you have to do that. And it set the rule, at least at that time, on whether you could advertise or not. So Regulation D was a big, big deal. And in Regulation D, there are a number of rules. And the rule that was most important was Rule 506. There was a 504, 505, and 506, which was all about how are you going to raise money. One of the things that's important about the securities law is it has nothing to do with the asset class, nothing at all. The securities laws are based on how do you raise money from the unsuspecting, weak, inexperienced, unsophisticated investor who needs protection of the government. That's what it's all about. And that's why they defined accredited investors who are rich and smart. Rich and smart investors don't need help from the government. Okay. But anyhow, 506 came along, and 506 is where I did all my business once that was passed. And 506 said, you can raise all the money you want, which was a big change. Before it was $5 million, period. But now you can raise all the money you want. You can have all the accredited investors you want. And before 1981, we really didn't know what an accredited investor was because there was no definition. And in order to promote capital raising, capital formation, which has been the whole trend of the securities laws ever since then, is how do we promote capital formation? Because small businesses get a lot of their money from the syndication world, from private investors. They go to the bank, they go to their 401k and pull out some money, and they do what they can. But if they need more money, they go to investors. So that's what happens. So in order to promote capital formation, Rule 506 said you can take money from 35 people who aren't rich or smart, and we call them sophisticated. Okay, unlimited accredited, 35 sophisticated, but you can't advertise. So that's Rule 506. Now, just as a segue, because I'm just going on and on, I'm telling a story here. Where are we now in that business? The private placement business, syndications and securities that don't go to the SEC. During the last 12 months, the SEC reports that this market is $2.7 trillion. It's larger than the market for new money raised on Wall Street. This is huge business. Probably a third or maybe even less is real estate, but it's huge business for capital formation for small businesses to get started and keep going. It's a huge business. I mean, right now we're doing an offering for a fiber company who's bringing fiber optics into apartment buildings. We've done distilleries. We've done patents for medical equipment. We've done all sorts of things, but primarily we do real estate. So from 81 to 2012, we operated under Rule 506. Then comes the Jobs Act. And the Jobs Act, in an effort to promote capital formation, says, you know that Gene Trowbridge is out there. He's got some good offerings, but there's no way he can tell all the people who would like to invest with him about his offerings because he can't advertise. And there are a lot of accredited investors who'd love to invest in Gene's offerings, but they don't know about them because he can't advertise. So let's solve that. Let's let Gene advertise to the rich and smart people, to the accredited investors. And so they came up and said, well, we'll just keep what we already had. We'll call it 506B. And we'll bring a new one in that we're going to call 506C. And there's only two changes. In 506C, you can advertise, generally solicit, but you lose the right to take the 35 sophisticated investors, because if you're advertising, you don't know who your investors are. So that adds extra risk for those sophisticated people who aren't rich and smart. So we'll just put them back in 506B, and you can continue to do that. Today, 96% of the $2.7 trillion is raised in 506B. That's an amazing statistic. And part of that is because the broker-dealer community, all the stockbrokers out there, I'm going to use a term that you probably don't even know. They have Rolodexes with 1,000 investors in them that they already know. They don't need to advertise. So they just stay in 506B. If you go to 506C and you raise money from people you don't know, how do we know they're accredited? In 506B, you know them. They just check a box and say, Gene, I'm accredited. I know you guys. I know you're accredited. That's fine. But if I just get a check, I wouldn't know who it comes from. So we have to have third-party verification. And that's really, well, 506C is. Go ahead and advertise, take money from the rich and smart people, but we do need to verify that they're accredited. Now, I'm getting ready to answer your question. Which do you do, 506B or 506C? I have no idea. We talk about that in my intake interview with you, and most of the people use 506B still. 506C has some use, but not very much. If you don't have a track record, guys, if you haven't done a lot of offerings and show people what you can do, who's going to send you that $100,000 check? They don't know you. You don't have a track record. So we all start in 506Bs and then we move forward. Okay, so that's my story. They're kind of long-winded, sorry, but that's my 50-year career right there.
Yeah. And it's actually a perfect segue to one of the questions that we had that came from our audience on Facebook. And this comes from a girl named Amy. And Amy does a fair amount of syndications. And she said, if you had to choose between doing a 506C and a DST, Delaware Statutory Trust, which would you pick? So you didn't mention that. I'm curious if you could break down what a Delaware Statutory Trust is and whether that's something that is a 506C or something else that you would potentially use.
So that question is like comparing a pineapple and a kumquat. They're totally different things. The securities laws talks about how you raise money from investors. And so there we have 506B or C in Regulation D. A Delaware statutory trust is a manner in which you take title to a property. And then the IRS has written certain rules that kind of mirror a 1031 exchange. A Delaware statutory trust is a method by which you take title to property. It's similar in its goal as a 1031 exchange, so you can move your equity from a piece of real estate you own today into another piece of real estate without reporting capital gains. Has nothing to do with how you raise money. A Delaware statutory trust could be a 506B or a 506C offering, depending upon how do you attract your investors. Are you dealing with just people that you know, 506B, or you're advertising? Okay, I would say most Delaware statutory trusts are going to have advertising. So they're going to be offered on a 506C or a REIT or some other way to raise the money. But that's a set of IRS rules implied over a trust. And I have written offerings for DSTs. I don't do the trust documents because, as it says, Delaware. So you probably need to be a Delaware attorney and know the rules on the trust document for that. But when you go out and raise money, it's still the securities rules, and you need the private placement memorandum.
So, Gene, you've mentioned the term accredited investor a lot, and we've all heard it several times. Can you define for our audience what exactly it currently is an accredited investor?
Sure. And it's evolving. Okay, it's evolving. Once again, I'm just gonna remind you that they keep changing the securities laws, at least until now, to promote capital formation. Okay, not to make it harder, but to promote it. So in 81, when Reg D was passed, they said, here's who's rich and smart. Anyone with net worth of $1 million. Any individual taxpayer filing their own single tax return who makes $200,000 a year and does that regularly, or any couple filing jointly that make $300,000 and does that regularly. Rich and smart. Now you have to think that in 1981, $1 million was a lot of money, and making $200,000 or $300,000 a year was a lot of money. Okay, so just keep that in mind. And here comes the crash of 2008. And in the crash of 2008, a lot of real estate syndications went bad. So Dodd-Frank came along and said, we would like to change the definition of accredited investor. We would like to, in the formula of net worth, we would like to remove the value of the person's primary residence. It makes a lot of sense. I'm living out here in California, and there are people who bought oceanfront houses for $100,000 in the 60s and are now living in their $5 million house on Social Security, and they're deemed rich and smart. And the government doesn't spend time and energy protecting the rich and smart people. So they said, let's take the net worth of your house out of the $1 million. Well, that hurt. That took us, I've seen some statistics, maybe it took a third of the accredited investors out of the picture of accredited. And you can imagine where that was from. The coastal areas, the high income areas where houses had appreciated like crazy. It probably didn't affect anyone in Iowa, but it certainly affected people in California. So that hurt. Now, in 2020, the SEC said, well, maybe just $1.00 set of rules for who is rich and smart isn't exactly enough. So they came out and said, here are some people who we think, regardless of how much money they have, are rich and smart and should be able to be defined as accredited. And the first one they said is stockbrokers, people who are in the securities industry, who are tested and fingerprinted and know all about the securities laws. Who cares how much money they have? They're smart. So we'll call them accredited. Well, that was a big change. And then another thing they looked at is, what's a household? Back in 1981, you're married and filing jointly, and we know you have a household. But you and I probably know all sorts of people where there are two adults in a house and they run a household, but they're not married, whether they're seniors or they're young or whatever. And so they said, they coined the phrase spousal equivalent. So now if two or more people are running a household and they meet the definition of spousal equivalent, they can combine their net worth to $1 million. They can combine their income just like a married couple would to get to $300,000. Okay, so that's good, because let's say they didn't have that rule and two people living together both make $150,000. Neither one are accredited because you need 200 and 200. But if you put it together, it's 3, and now the household is accredited and it can invest. That's a big change, and that's pretty good. Then they made another rule that says, we always had this problem. If there's an LLC out there or a 401k out there, has a lot of investors, and it wants to invest, how do you determine if it's accredited or not? You go through and look at each individual investor or what? So they just came out and said, we're going to do this. If the entity has $5 million of assets, $5 million of assets. We don't care who's in the entity. It is accredited. Well, that's good. So that promotes capital formation. And the last thing they did, which really doesn't promote a lot of capital formation, they said that key employees of the syndicator, regardless of their income or net worth, can invest in their syndicator's deals. If they're a key employee, they probably know everything that's going on, and so we'll let them invest. So that was all good, and that all promotes capital formation under expansion of the definition of an accredited investor. Now, I'd like to talk a little bit about what we hear. When Dodd-Frank came out and took the primary residence value out of the definition, they set a rule that every 5 years, the SEC needs to revisit the definition of accredited. So the last time they did it was 2002. So we're 2020. We're approaching 2025, and they're already talking about what changes they might make. And the buzz is $1 million isn't enough. 200 and 300 isn't enough. And they just go back and look at inflation from 1981 until now. That $1 million, maybe it should be 3 or 3.5 million. And the 300,000 for a family should maybe be 750. So the regulators would like to increase the simple dollar amounts. The stock brokerage community is going to go nuts because that's where they make all their money. They don't want that. So how that process works is, if the SEC would like to make that change, which they've always done this process, they publish something called proposed regulations. And there's 90 days to 6 months where people can write in their comments. And then they respond to the comments, and they come out with a revised proposed regulation. And then there's another series of comments, and then they finally make up their mind and they finalize it. It's probably an 18-month process, and nothing is set until they issue the final documents. So I was at an SEC meeting in March of this year, and that's all the buzz. We need to change the $1 million. We need to change the 200 and 300. And I think it might happen. It just might happen. So that's when I write the 5th edition, right? Kalani, that's why I write the 5th edition. When we go and change the definition of accredited investors. One of the other things that's always been floated is, why doesn't the SEC come up with a test? I mean, Christian, your question was about sophisticated. Okay, sophisticated. Well, why don't we have a written test that the SEC can administer? And if you pass the test, you can invest, because now you're smart. They don't want any part of that. They don't want no part of that at all. And the sponsors don't want any part of that. I don't want to grade these tests and all that. As the attorney, we already have too much stuff to worry about as the attorney. So I don't know what's going to happen, but if I were paying attention to securities laws as they're changing from today, I would pay attention to the fact that we might get a change in the definition of accredited investor.
So would that be a big motivation to, if you're working on something that's on a grand scale, to move it forward more quickly?
Well, I think we've got a lot of time. In our real estate offerings, very few offerings are open for 18 months. So you got a 60 or 90-day escrow. But I do think that would make a change. What it would mean, it would drive people back to 506B. Because now there are less accredited investors. I think this figure is about 16% of the households in the United States are accredited. Well, that's a big number. But if that went down to 10, whatever, okay, that's a smaller number. And now we need to go back to 506B. So you got to pretty much be aware of 506B all the time. Now, Mike and I were talking about this before we started. There is something that my clients do. They start out with a 506B, where they take sophisticated investors with whom they have a pre-existing relation. And so there's no advertising. And they raise as much money as they can, and then they get to a point where they're out of investors. And they can switch to a 506C inside of that offering. There are specific steps that your attorney will tell you have to take to do that. And then they can go forward and advertise and see if they can raise some money so they can have the best of both worlds. I just will tell you that advertising without a track record and without any personal knowledge of someone is a very difficult way to raise money. It's totally legal, but difficult. Let's talk about sophisticated. Should we talk about sophisticated for a minute?
Yeah. Let's make sure we define that so people understand what that means.
There's no definition. There is no definition. Basically, and in my YouTube channel, I have a YouTube called 3 Words, and it talks about sophistication, pre-existing, and substantive. Because to defend yourself against a charge of advertising, you have to show you had a pre-existing relationship with the person. You come to invest with me, I have to show that I knew you before I brought out this offering. Okay? Pre-existing. And it's more than just having your name in my database. I have to know something about you. So I would defend myself against a charge of advertising by having a pre-existing substantive relationship with you. That's pretty well defined, and I talk about that in that particular YouTube. But sophisticated is very nebulous. Does the investor or alone or with their advisor have enough information, business experience to read the documents, figure out what's going on, understand the risk, and understand if they can withstand the risk of investing in the deal? And so how do you do that? In the securities documents that we write for you when you do a syndication, we have a subscription book and we have an offering questionnaire. And if you're accredited, you're just going to check a box and say you're accredited. I don't know if you're sophisticated. I don't need to know. You're accredited, fine. But if you can't check the box that you're accredited, now I need to ask you some questions. What have you invested in before? What's your college? What's your education? What's your career? What are you doing? How much money you have in the bank? If you make this investment, are you not liquid anymore? All those things. And that's in the offering questionnaire, which gets submitted to the syndicator. And then the syndicator looks at that and makes some decision if that person meets the definition of sophisticated. But no bright line rules. Very unfortunate.
And is that the term that I've heard of, a suitability test, essentially?
Suitability test is, hey, this is a 506C, you all have to be accredited. Hey, this is a 506B, you have to be accredited or sophisticated. Now, I can take that farther. We have a company that comes to us every year and does a $5 million offering, and they take a minimum investment of $250,000. And kind of interesting, they raise the $5 million, and what is an entity with $5 million? It's accredited. Now they can go and buy 5 $1 million shares in big offerings out there that none of their people could invest in if they hadn't gone into this fund. So their suitability standard is $250,000. If you don't have that, you're not suitable for our deal.
We were talking, you had mentioned advertising quite a bit. Currently, I know times have changed back from when you were a syndicator yourself. Have you seen any successful methods of advertising, whether it's in-person events or paid advertising on social media or on Google? Do you have any tips that you can give some of the sponsors that may be watching this right now that have a 506C offering or have one that's coming up and they're looking for more accredited investors?
Yeah, I deal with that every day. Every day. what's advertising? Well, what is advertising? You go out and talk to people you don't know. That's basically what it is. I think the most common ones would be in-person presentations to groups. Stand on the podium with a group of people that you gathered together to talk about the fundamentals of investing in apartments. And after you get through with your generic presentation, you say, and I have an offering, and you can invest in this offering. I've got a fact sheet. I'm going to give it to all of you. If you're interested, call me at the office. That's very effective. The question is, can you get people to come to the meeting? Okay, that's what your advertising is all about. And the other is simply social media, LinkedIn, Facebook, whatever you can do. Social media is it. However, you might hear on the radio people advertising real estate investments. And somewhere maybe at the end of the advertisement, it says this is for accredited investors only. That's your dead giveaway. If they don't say that, it could be a REIT. It could be a public offering. We don't know. But if they say for accredited investors only, it's a 506C. Now, a lot of companies do advertise. I heard an advertisement yesterday on the radio for someone who's raising money to do RV parks. And their message was the cash flow from single family rentals is gone. So let's invest in RV parks. And they go through all this. And then at the end, it says, the offering's only made through an offering memorandum and it's for accredited investors only. Okay, 506C.
Yeah. Now, I believe there's also some rules of whether you can raise money if you're involved in a transaction. You'd mentioned key employees, but what all does that define if you wanted to raise money for a syndication?
Oh, okay. One of the most asked questions. Let's do an analogy of for sale by owner in real estate. I can sell my house without a real estate license, right? For sale by owner, but I can't sell yours unless I have a real estate license and a real estate license in the state of Utah. The securities world has their own version of for sale by owner. It's called the issuer exemption. We have this LLC where all the investors have invested, all the members are up there, and someone needs to manage it. So there's the manager LLC. The manager LLC is the issuer. If you're a member of the issuer, you can sell your own securities. You can sell the securities that are up there for sale by owner. No one can sell securities of someone else unless they have a securities license to the broker-dealer. So if you want to, let's say you're out trying to raise money and Gene comes to you and says, I could put a couple $1 million in your deal. I've got some investors. I'd like to be able to do that for you. Well, you need to figure out some way. You need to first ask me if I have a securities license, which I don't. Then you need to figure out, and as an aside, none of my clients have securities licenses because of the issuer exemption. You don't need that regulation. You don't need those headaches. You can sell your own security. So if you'd ask me if I have a securities license, and if I don't, you'd say, well, how are we going to get you into the issuer entity so that you can sell your securities? Because now you're an issuer. And then my question to you is going to be, will you pay me? And your answer is no. The SEC rule is no transaction-based compensation. Sounds like commission can be paid to anyone who doesn't have a securities license. Now you can get part of the deal. I might come in and I'll say, I'll raise all the money for you. I want 20% of the promote of the managers and the fees and everything. That's fine. But it doesn't depend upon if I'm successful. Okay. It can't be tied to how much I raise.
Yeah.
So my legal word is don't do that. If stop Gene from asking you to do that, and don't take Gene's offer, because everyone's in trouble. If the deal goes bad, I'm in trouble. The investors I put in your deal without a securities license can come to me for rescission, and I'm personally responsible to give them all their money back. I don't want to do that. And I think a lot of people who want to raise money for other people don't understand the ramifications, and then you will be in trouble because you've used unlicensed broker dealers to sell your securities. Let me give you something that I like to. I wouldn't be happy if I got off of this without covering this. I think there's 4 questions a passive investor should ask, and I've always felt the same way. And these are the 4 questions. Number 1, guys, if I'm going to, well, Christian, you've got an offering. I like your offering. If I send you the $50,000, Christian, now you have my money. What happens if something happens to you? If you, Christian, if you don't have an answer, that I've got a partner over here who's in business with me, and we're in the manager entity together, so there's continuity. If you don't have that answer, I don't have to ask you any more questions. I'm not going to invest with you, and I would advise everyone who calls me and says, what do I ask? And I said, the first question is there continuity? If you are in an LLC and you're the only member in the LLC and something happens to you, the LLC dissolves. The state will dissolve your LLC. Now, who's running anything? Who can sign on anything? Your investors are totally in trouble. So don't do that. The next question an investor is going to ask is, hey, have you done this before? And all of us have had to say no one time, right? We've all had to say no until we get our first deal done. And so it's real important to get your first deal done so you can say, hell yes, once. That's all you have to do, once. And I don't mean that you buy it and hold it for 5 years and you double their money and all that. You find the property, you get your documents, you raise your money, you start managing the property, and you send out your first quarterly report. You're a sponsor. You're a syndicator. Yes, I've done it. That's an important question. That doesn't mean you should never invest with someone who has never done it before, or no one would ever get started, right? When I went out and did my first deal, I had all sorts of real estate background and CCIM teaching and all that stuff. So I could overcome the fact that I hadn't done a syndication before because I had some strength in the real estate industry. But this is a people business, much more than real estate. Managing those 850 investors I had and all that, much harder than just managing the real estate, because many times you have a property manager. You don't manage the real estate. So it's the people. It's the people. The third question a passive investor should ask is, are you going to have any skin in the game? Are you investing? First of all, you should never syndicate anything that you wouldn't personally invest in. I don't think that's a good idea. And how do you get skin in the game? You're going to sign the mortgage. Okay, put your name on the line. It might not be recourse, but there's some provisions in there that are recourse. And it does eliminate your ability to do other things, because now you've given your financial statement to this lender. And number 2, you probably have to put some cash in. You're not required anymore. At present time, it's not required that you have any ownership in the manager entity legally, but marketing, if you don't, you're not going to raise any money. It's really a marketing question. And then the fourth question is, I'd love to invest with your deal, and you've got a track record and your continuity, but what happens if something happens to me? Is there any liquidity provision? And that's what you guys are working on in your industry, trying to provide liquidity provisions. And in my documents, Article 11 and 12 talk about voluntary liquidity or involuntary liquidity. And you have to have a well-drafted plan so you can sit down with a potential investor and say, yes, we've got that solved. And that probably isn't something that's in the document you get from LegalZoom. Probably not in there. So those are the things, and I haven't said anything about what's the investment yet. that's a whole nother series of questions, but I don't even have to ask that questions if you don't have continuity and maybe you've never done this before and don't have a background and you're not going to put any of your own money in there. I don't need to do anything.
Those are good questions. Thanks for
hard-nosed questions, right? Hard nose, yes.
Yeah, well, thanks for that, Gene. We have another question from Mike Howard with AKA Partners. He asks, how much ownership does one have to have in a sponsor entity to raise funds for that project?
There are two answers. One is legally and one is marketing. There's so much of this stuff that always has two answers. When I was syndicating, at that time, the sponsor had to own 10%. 506C. Currently, there's no requirement legally. But you just heard me say that one of the questions, the third question is, do you have skin in the game? Without skin in the game, I think that you're going to have trouble raising money. And skin in the game might very well just be signing the mortgage. But generally, it's a combination of signing the mortgage and having some money. Let's say your minimum investment is $100,000 that you want everyone to put in. That doesn't mean you have to put $100,000 in. You have to put in, well, it's a marketing question. I don't know. Will 25,000 satisfy? Will 50,000 satisfy? If you have to put 100 in every deal, pretty soon you're going to run out of money. So you don't have to match what everyone else does. That's a marketing question. But today, legally, there's no requirement.
So, Gene, from what I understand, basically the only reason to do a 506B versus a 506C is if you want to utilize investors that are not accredited, that you already have an established relationship. Am I understanding that correctly?
Absolutely. My biggest client in terms of the number of deals, 164 deals since 2014 that I've written for them. 506B, only accredited investors. Doesn't want to mess with sophisticated investors because everything they do is development, so there's risk. Only accredited investors, and one of the advantage of leaving it in a 506B is, number one, he doesn't have to advertise. He's got plenty of investors. Number two, in a 506B, because he knows everyone, all they have to do is check a box that they're accredited. If he could do exactly the same thing, 506C, but his investors who he knows and has invested with them before would have to go to a third party and have some third party verification. And they don't want to do that. So 506B, it's easy. And, it's very easy to get a Reg D offering on the marketplace. Most attorneys can get it done in 3 or 4 weeks with you if you have the complete documentation. There's only one form to sign, to fill out at the SEC. It's the Reg D form, and your attorney can do that. When the states want to know if you're raising money from investors, from citizens of their state, so the attorney will fill out a state securities notice. It's all done online. So it's pretty easy. Now, we haven't talked about Reg A or Reg A plus. That's another kind of private placement. But there, it's almost like a mini IPO. You have to go to the SEC. You have to have them look at your documents. You have to prove your assumptions, and then they give you a permit to sell. That the attractiveness is there, as you can raise. Well, you can raise up to $75 million a year from anyone. That's the only place you can advertise and take non-accredited, non-sophisticated investors. But that just doesn't work in real estate unless you're doing a blind pool, because it's going to cost you $200,000 and it's going to take 6 to 9 months to get it approved. And you're not going to do that in a real estate syndication unless you want to do a blind pool. And we've done a few regulation A plus offerings, but with the other problem, it's only 75 million. I mean, I've done probably 20 offerings in 506B that are over 150 million.
And is there a point, a number where those rules change there?
506 B or C, unlimited amount of money that you can raise. and that came out when Reg D was formed, unlimited. Prior to that, you could only do 5 million. So that's a big deal. And Regulation A, it's 75 million. It was 50, it went to 75, once again, in an effort to promote capital formation.
Now, the other side of that, do you feel like you potentially invite more scrutiny at a certain number by the SEC?
No, there's no scrutiny in a 50 in a Reg D offering. If you do a Reg D offering, it is preempted from state scrutiny. All the state can get from you is a copy of your Form D, which is an informational report, a check, about $300 every time, and how to get a hold of you. But they can't regulate, they can't look at. When Reg D came out, there was something called blue sky rules, where every time you did an offering, you had to get the state to approve the offering, and every state has different rules. And it was burdensome to the states. So the SEC came along and said, anyone who does a Reg D, we're just going to preempt it from state regulations, and state authority will take care of it. If someone is a crook, come to us, we'll take care of it.
So let's dive into that other side of this, because all of these rules are in place, like you said, to protect the public. What happens when things go bad? Now, we can talk about if somebody's a crook, like you said, but sometimes there's just the risk of investment. So maybe you could go through the differences of whether you did something wrong in your offering or the deal just didn't go the way that you expected. What are the things that you're going to face?
Well, if things go bad, you'll get sued. I guess the chances of you calling the SEC and calling the state securities commissioner and saying, hey, I lost $20,000 in a deal, I think the guy's a crook, will you arrest him? You know, they got guys like Madoff that they're working on. They're not working on your deal. So generally you hire an attorney and you take him into court. While the securities laws are a criminal statute, you generally get into court on a civil case. And the lawsuit starts with, you sold a unregistered security. Well, we kind of went through that before and said every security has to be registered unless it's exempt. And you can have an exempt security if you follow the rules on Reg D. So if you followed the rules, you have an exempt security and you win that one. Where you lose that one is if you've advertised. The number one issue of blowing your exemption is actually advertising. But let's say you win that one. Okay. And then the next one is, oh, you sold securities and you weren't licensed to sell securities. Well, we've already covered that. If you are the issuer, you don't need a license. So there you go. Now it gets a little more complicated. The issue is, you didn't tell me everything I needed to know to make an informed decision before I invested. And because you didn't, I invested and therefore I lost money. Well, now we're talking fraud, misrepresentation that can elevate itself to a criminal offense, but generally it's civil. And so then we have an issue of, in your selling process, what did you hide? Because you knew that if you told me this, I wouldn't invest. So you hid it? Or what did you tell me by knowing that if you told me this, which wasn't true, I would invest? So those are the two ways that's going to go. Thirdly, and that's the toughest one to defend yourself. Let's just talk about this. In 2006, I was writing offerings, and I never once in an offering said that in August of 2008, the commercial mortgage-backed securities loans were going to go away in one day, causing the collapse. I didn't know that. In 2018, I didn't write in there that, next couple of years, there's going to be this disease, And if you're buying apartment buildings, you're not going to be able to inspect every unit. You're not maybe going to be able to collect all the rent you want to collect. I didn't know that. Okay, so we're not crystal balling this. You know, you do what you do. And the whole securities law is based on full disclosure. Did you give the investor all the information they needed to know before they invested so they could make an informed decision? That's the whole deal. And so that becomes an issue. And then you can get into something. I just researched a case because it came up in a discussion of what if a syndicator took money out of a deal that was, let's say, supposed to buy building A. And that's what he told everyone. And he told them they were going to double their money. He took the money and bought building B. Did a relatively fast turnaround, gave everyone back 3 times their money. Sounds good, right? No harm, no foul. That guy's in jail for 84 months. The Justice Department came after him, and so he took $6 million over here. He invested it, and he gave $18 million back. Well, he has to pay the people the $6 million he took in the first place, even though they got it back. Wire fraud. Okay, so there is no such thing as a no harm, no foul defense. So, I mean, you think about Bernie Madoff, what did he do? He raised money from people, and then he used that money to pay off other people and told them that was their earnings. He obviously went to jail. A lot of people steal the money. This is what the state regulators are so worried about. They see all the fraud where people raise, especially in blind pools. They raise money and they buy fancy cars and they buy new houses, and the money never gets invested where it should invest. And they raised a lot of money from people who, under the current set of rules, are supposed to be rich and smart, and they've lost everything. So the state regulators are the ones who want everything raised to 3,750,000. They want to protect their citizens. So that's what happens. And you're in civil court, and you win or lose. We just had a previous client of mine who, for one reason or another, wasn't a current client of mine in this deal. Did 3 offerings to build custom houses in Newport Beach. And one of them got a little underwater, so he took money from these funds and went over here and shored up that, and got caught. How do you get caught? Well, the financial statements come out every quarter. And all of a sudden there's a $2 million influx into this financial statement. Where the hell did that come from? And there's $2 million missing in this statement. And if you have the same investor in both statements, you're in trouble. And that's exactly what happened. He's in jail. We haven't even waited to see if the houses are going to sell. Possibly these 2 houses people are going to make money on. I don't know about this one, but it doesn't make any difference. He's in jail.
And it sounds like what you're getting at is, as long as you file the proper forms and you do what you say you're going to do inside of those forms, you're covered.
Yeah, you read the book. The first 2 chapters, I go in probably in boring detail about fraud and intentional misrepresentation and just non-intentional representation. So you have to be careful. And that's really where you're going to get caught. You didn't do what you said you were going to do.
Yeah. Well, Gene, all the rest of the questions that I have from people on Facebook are much more in depth, and I don't believe we have time to get into those. So I would love to just ask you, is there any final pieces of wisdom that you would like to share with folks that could add to the conversation that we've had today?
Well, I think the most important thing is you need to find yourself an attorney. This is not a do-it-yourself business. It's not a nothing down business. You need to have some money to do this. You need to find yourself an attorney who will mentor you and guide you and draft the right documents. I mean, your investors aren't stupid. They're going to look at your documents, and if it says, Trowbridge Equity Group LLC is selling shares of stock, and the president is Gene Trowbridge, you've got three things that don't fit. Because LLCs don't sell shares of stock, and generally they don't have presidents. And smart investors read that stuff, and you better be careful. So if you're an investor, read it, and don't be afraid to ask the syndicator questions. They're ready to answer your questions, and this is not do it yourself. Give yourself plenty of time. If you're going to do a syndication, you need 60 or 90 days from the time you hire an attorney until the time the deal closes, and do it legally. Because if you don't do it legally, the civil penalties will get you in. If it goes into criminal, there's no problem of going to jail. There's plenty of room in our jails. Thank you guys very much for having me. I appreciate it.
Absolutely. Now, obviously, the attorney they could reach out to is TNL. If somebody wants some general information, they should probably go to maybe your YouTube channel. If somebody is more serious, then what's the best way for them to get a hold of you?
Well, just send me an email, Gene at TNLLP. Send me an email. If it's a complicated question, be sure your phone number's on there, because I use email as a phone call. If it's a complicated question, I want to call you and talk to you rather than just say yes or no. It doesn't help you. And we have a lot of stuff on our website that's good, and our YouTube channel. Between interviews, I think I have 37 interviews of my clients talking about how they get in the business, what do they see coming up in the next 3 years, and what advice do they have for rookies. And it's always the same advice. Don't do this yourself. Back to my number one question, continuity. Don't do this yourself. Okay, guys, thanks so very much, and good luck to Fundication and everything you guys are doing. I think it's a great idea, and I look forward to being involved with you as we move forward and your company grows.
Thank you, Gene. And for those of you watching right now, if you don't yet have a copy of Gene's book, you should go to his website. Gene, you have this available on your website for free. All they have to do is pay for shipping, correct?
$9.95 for shipping, and we'll ship you a hard copy.
Yeah, so be sure to go and get yourself a book. Make sure you're following regulations and operating as a true syndicator. And Gene, we appreciate your time, and thanks for coming on. And for those of you watching another episode of the Fundication Show, thanks again for watching. If you'd like to see more of our episodes, you can find us on YouTube. It's just search PREIshare in the search engine, and you can watch all of our YouTube videos. Thanks again for joining, and have a great day.